Take your seats, please. We'd like to reconvene. Thank you so much and appreciate the break. And now we'll go back to the presentation.
Okay, guys, so we only have a few more slides left, and we will then be able to have lunch. So we're going to talk about due process for students, because it's very important that we touch on the different components of our community, students being our foundation, our reason for being. So due process for students, we're on slide 28. And with respect to students, they have students who are subject to expulsion and other disciplinary actions are entitled to receive both notice and a chance to have their case heard before some decision-making body. That's the United States Supreme Court case. And in school disciplinary proceedings, due process rights are not coexistent with those of defendants. In other words, it's not like the civil or criminal trial. Thus, the due process may be satisfied through submitting questions to be answered on cross-examination, although not confrontation, and students are entitled to notice and opportunity to be heard. So I want to make sure we all understand that what I'm giving you is what the law says with respect to due process. If there are situations where you feel the board can review this and take this under consideration, if there are procedures that you think work better for your community that provide a little bit more explanation, a little bit more opportunity to be heard, then you guys can take that under consideration. But what I'm giving you is what the law says that you have to do, and every community is different. You know, there's some communities that focus more on trying to be a teaching moment, provide more explanation of things. So you guys and your board can take this and have some time for reflection, and then see if the procedures that you have are what meets your needs. But the procedures that we're giving you are the law, and we've also reviewed the procedures that you have and found those to meet legal compliance. But that doesn't mean that you guys cannot review them to see if there's something that you guys may want to elaborate on a bit. So students are entitled to a notice, and an opportunity to be heard. So we're going to talk about informal hearing versus formal hearing. And this one is really important because this talks about the balancing of resources versus, how you're going to spend the resources with respect to the hearings and the other things that you have to balance in terms of being an educational institution. That's actually the review that the court undertook in this case. With regard to the level of formality required in student conduct hearings, the United States Supreme Court looked at this issue and said that education is a university's first priority. Adjudication of student disputes is at best a distant second. So this is why we have a level of informality with student hearings. But that's why I'm saying you guys want to look at what the law requires and then consider what you want for your community. Formalizing hearing requirements would divert both resources and attention from the educational process. That is a case that came out of Michigan. I've put this in here, not that it's controlling here, but because it allows you to look at the court's reasoning in this type of, or a court's reasoning. So the university is not required to transform its classrooms into courtrooms in pursuit of a more reliable disciplinary outcome. So when you guys are considering if you want to increase the hearing process, you just want to look at the balancing of resources. So we have another hypothetical question. And this is with respect to how one handles a student disciplinary issue. I'll give you guys a little chance to review this one, and then we're going to go through the IRAC with respect to the students' rights. Now, remember, the students have a property interest with respect to their contract and the right for their education once they do their admissions and enrollment, and they pay a fee for this. So we're looking at both. I'll just ask you guys, are we going to be looking at a liberty interest as well as a property interest, or are we just going to be looking at one? And can you do both? So that's what you want to think of when you're reading this hypothetical. And also, you guys are going to be the controllers now. You're going to be the VC of finance, and you're going to think about how you're going to allocate resources. So we're on slide 30 now. We also had, my husband and I went to Boston University Law School. We also had Alan Dershowitz as our crim law professor. So it was great being on the other side. We got everybody that left Harvard, retired, came to our school. So we're going to talk about the evidentiary standard. I still remember sitting in that class, the fruit of the poisonous tree. Still remember that. So has everybody had a chance to read through the? All right. So we have Patty Hearst, a journalism student, Coastal Hills Community College. So she denies being engaged in conduct that is considered misconduct on campus, punishable by temporary suspension. She insists that the district must prove her guilt beyond a reasonable doubt. So that's one of the issues we're going to spot. Not only is it Ms. Hearst's standing, what interest she has, but also she's asking for an evidentiary standard, a specific evidentiary standard. And she says, you guys can't punish me unless you prove that I'm guilty beyond a reasonable doubt. And the district's thinking, okay, I got like a whole lot of other things to do besides deal with you, Ms. Hearst, but we're going to consider this. Ms. Hearst demands that she and her attorney be permitted to present evidence in her defense and object to evidence offered against her at a hearing that's recorded by a court reporter. So also, who's going to pay for the court reporter? Who's going to lawyer up? So, and then what process is due? Is the district required to comply with Ms. Hearst's demands? And what is the evidentiary standard? So what does the process do? That's right. That's right. And what is the interest or standing at issue? Yep, there's an alleged violation with respect to her misconduct, which could be temporary suspension, and she has a contract with the school to allow her to be educated, so she's going to miss out on classes if she gets suspended. So she has an interest, she has a property interest, and also, what happens if the word gets out that Patty Hearst, who's a journalism major, has been disciplined at school? How is that going to affect her ability to get a job as an intern, or how is that going to affect her rights? So does she have a liberty interest? And then what's the statutory framework applicable to the issue? Well, let's see. We're going to go back to slide 6, and we're not going to find it. I'm going to tell you guys already, we're not going to find it in slide 6. Why? Because the answer to that is going to be in your policies, your student conduct policies. You have a student disciplinary policy there. So that's where we go. So if you look on page 11, sorry, not page 6, page 11, those are the laws defining categories of community college employees. And you'll notice that you see just employees. So we don't have statutory frameworks, a statutory framework for students. We don't have one. You don't see trustees either, and you don't see volunteers. And that's why we default to the liberty interest and to the case law, because there's not always a statutory framework. So we're going to go back to slide 30. So with respect to Ms. Hearst, let's talk about the process. So we're back at slide 30. We've got a few issues here. We've got the student disciplinary process. It's adopted by the Coastal Hills Community College. We also have the evidentiary standard. Now, the evidentiary standard is preponderance of the evidence with respect to student conduct issues. And the reason that is because it's an informal hearing process. And if we use a higher standard, then that means that there has to be a different level of research and adjudication. And that takes us back to the cases that we see versus informal versus informal hearing, which are on slide 29, that talk about the first priority of the district being education.
I just wanted to clarify, you have your clear and convincing evidence standard, you have beyond a reasonable doubt standard, and then you have your preponderance of an evidence standard, which is, 50% plus a feather is often what it's called. So just so you understand, and the other two are normally in a much more serious or criminal situation.
And so oftentimes the evidence standard is directly related to the interest at risk. And so we're talking about a temporary suspension, and we're also talking about district policy with respect to the student adjudication or student hearing process. And then we're talking about the case of University of Missouri versus Horowitz, where the court said that you could still have a informal hearing of student disciplinary procedures, because if you start to spend the level of money that's required to recreate court hearings, you're going to be putting a lot of resources into the lawyers and the legal support as opposed to the education. And oftentimes with our budgets in community colleges, you have to do the balancing.
Meredith, I have a question about student due process. I have a question based on anecdotal information, is that often the person who investigates a student accusation is also the judge and the jury. So it's the same person doing all of it. That doesn't seem to be fair. And so could you comment on that?
Well, frankly, I think it's very important. Going all the way back to common law, one of the reasons that we have rules, right, is so that people are treated fairly, so that there's some sort of expectation of how things are going to go, but also people have to feel that it's fair for it to work. So the appearance of impropriety is extremely important. It flows through just about everything we do in a public entity. That's why, even our procurement, there's certain rules that you can't have the appearance of impropriety with respect to conflict of interest. You can't have it in how you do your bids, and you can't have it in your hearings as well. There has to be the feeling that you're not judged before you have a chance to present your evidence. So I'm going to see if Larry and Guy have a different perspective on this, but frankly, the way that administrative hearings are conducted with the entities that I work with, the person that collects the evidence is not the person that makes the decision. I don't advise that, because people are not going to believe in your system if the same person's doing everything. And the only way you get so many people to be connected with a thread of policy or law is if they believe it actually works. It's not just retribution. It's also belief that it is there for your best interest and for the best interest of the institution. And so you have to maintain fairness. You have a higher burden with respect to fairness. See if either one of these guys.
I would just say that I agree that it's not necessarily fair if that person plays the same role all the time. But in the real world of practicality, often you may not have a department or even a college that has the resources to have more than one or two Title IX people, for example, or other folks that are. And so it's clearly a balancing that you're going to have to try and look into. In a perfect world, you would want to have a neutral party actually review the information that is gathered as part of the investigation.
I think
So go ahead.
This microphone's on. There, it's on with the red. Yeah. That way we won't have to keep handing these microphones around. Once again, it comes back to an initial analysis of what's the fundamental interest that you're protecting. A college student in California really doesn't have a fundamental right to attend college, but they have a right to, when they're enrolled and they're taking the class, before you deprive them of that right, they have a right to some due process. Now, generally, the general notions of due process is you have one person investigating and then another decision maker somewhere up in the chain. Doesn't mean it has to be like an impartial hearing officer from outside the college. It can be an internal process, as long as there's someone who has made the investigation, presenting information to someone who is not involved in the investigation to make a final decision. I have not looked at your student discipline policy, so I'm kind of talking off the top of my head here. But in general, constitutional provisions, when it comes to due process of an interest like of a student, like a college student, it's just so long as somewhere along the chain there's some impartial decision maker. In other words, a lot of times what will happen, and I've seen, trying to think back the college district that I was in, I was trying to think, and Meredith may correct me here. The situation was if the student would do something incorrect, the dean of the particular area would come in, talk to the teacher, talk to the students, develop a statement, and then indicate to the student, well, I as the dean, I believe we should suspend you for the next semester. And the student would have the right then to meet with the dean, sort of this kind of a semi-skelly. And then if the student was dissatisfied, they could appeal to the college president, and that's where it would stop. Okay. So there's, even though the college president supervises the dean and runs the college, it's still under law considered as an impartial enough decision maker, because the nature of the interest is not what they call a fundamental constitutional property right. It's not.
Okay, and in our district, I'm looking at our college presidents here, so that a situation where a student was given a decision by a dean that the student wanted to challenge, okay, would they go to the VP of Student Services next, or go straight to, okay. I just wanted to get the chain right.
The chain,
just the next step up.
Someone who was not doing, as Meredith pointed out, is not the investigator, the police department, and the judge and the jury. They're the police department, but then there's a judge who's somewhere up the chain. There's been a lot of litigation over, well, gosh, how can someone who works for the college district be fair? Well, the courts are not concerned about that. What they're concerned about is that the person is not prejudged the situation by investigating. In other words, they get the information from all sides and say, look, no, I think we need to go forward with discipline.
That's great. Thank you.
So then what we are looking at is a balancing. How do you make sure you give the impartiality and that you also conserve your costs so that you're not having to bring outside people in? And we have a question.
Yeah, I just got through reading our student conduct policy. It's called 5500. And I'd recommend that the lawyers here read that. I'm certain that you would not want to be subjected to that kind of justice. The way it works is there's a student conduct officer, and he can have somebody else do the investigation, or he can just do it himself. But then there's a hearing. And you know who's at the hearing? He's the judge, he's the jury, he's everything. You're entitled to have a lawyer, but you're only given a notice 5 days in advance of the hearing. And if you want a lawyer, you have to give notice that you want a hearing 5 days in advance of the hearing. So you have no time to even get a lawyer. And then when you have the lawyer can sit beside you at the hearing, but there's no panel because last year, I think it was last year, the panel was eliminated. There used to be 3 people on a panel. Now there's just a student conduct officer. And it used to be that at least you could ask, relay a question if you wanted to interview the witnesses against you. You used to have the right to submit to the student conduct officer questions, and he could ask the person, the witness. Now you can't even do that. And your attorney can't speak during the hearing. And that's what I would call a kangaroo court. And I don't care what rights these people have in the Constitution or in the state constitution. This is just not right. And the students deserve better than this. And none of you would want to do this. Now you can make some appeals, but you have 5 days to appeal too. And I don't know how fast you people are at making appeals, but if you're a student, your notice is by through the student email. So if you don't check your email, well, you're dead. So I think that needs to be needs to be looked at. Thank you.
One of the things I'll point out is that policies are important, not just because everyone has the expectation and they have that thread that goes through the institution they feel that it's fair. It's also important because if you don't have a policy that withstands legal scrutiny, you're not going to win on an appeal. That's one of the first things that a court's going to look at. Was there due process? Were the rights, were the students' rights respected? Did it go according to law? So I know as a board member, the first thing I look at is what's the process? What's the policy? Was it fair? Like we learned from Archibald Cox. And so you want to make sure that your policies are fair. It's very important, as Dr. Hawley said, you got to make sure that what you're doing is actually fair, because you're not going to be able to withstand scrutiny yourself with respect to the policy. The court oftentimes will remand something that they don't feel is fair, even with student expulsion. They'll say, nope, do over. You know, and so you want to make sure that your policies are fair. So I think that's a very good point.
Meredith, I just would like to add that when we're talking student misconduct, generally we're talking about the board policies or the student conduct code. But if it's a certain type of misconduct that implicates federal law, like Title IX and OCR, Office of Civil Rights types of things, there's a clear, well, it's not as clear as it was since the rescission of some of the Dear Colleague letters. But the reality is that, Title IX has a separate type of best practices, and there's a separate type of way to deal with that kind of a situation. So just wanted to make sure we had that distinction.
Okay, so and we're going to go over Title IX a little bit later, and we do have the Title IX updates that came from after the rescission of the Dear Colleague letters. We've got the latest from the Office of Civil Rights under the Department of Ed with our Department of Ed Chair, Betsy DeVos. So we're going to go back to the hypothetical question. What processes do? We heard informal hearing, right? Is the district required to comply with Ms. Hurst's demands? Nope. Some of them maybe, yes, she could bring her attorney, but can she change the evidentiary standard? Nope. And what about the court reporter? If she wants to pay for the court reporter, she can, but she can't control your budget and change the evidentiary standard, because would that be fair to everybody else? And what resources are you going to reallocate because of the requests that you're getting from one student? Oh, you're asking me, is it normally audio recorded? I don't believe that there is a recording requirement at all. So I think that with this one, I put in court reporter so that we would, because I know that it costs at least $1,200 to get a stenographer because I just got out of trial. But generally, it's not audio recorded. Somebody could ask for that and then pay for the stenographer, and then have both people get the recording. But right now, it's not.
In practical terms, it's not required. But if they're going to record it, then obviously you would want to have a copy of the recording, and then ultimately, if it is appealed, you may want to have a stenographer actually transcribe the record and the transcript and that kind of thing, just in case it continues to move up.
I'd like just a little more clarity on audio recordings, because we have had a situation, not with students to my knowledge, but with faculty in a hearing, and they were told that it had to be audio recorded. Is that your understanding, or just that it could be?
Context, Trustee DiMartini. Roughly the.
Is this a disciplinary matter with?
Yes, a disciplinary matter.
There may be language in the contract that provides for how the hearing transcripts and the hearing will be conducted. We'd have to review those kinds of.
Okay, if there is, then certainly I would understand that. If there were no wording in the contract about audio recording, would it require both sides to agree to it?
For example, if you're going through the progressive discipline under your contract, generally those aren't recorded, like when you're having a reprimand hearing or a meeting. I always call them meetings, not hearings. Meeting or a formal meeting to talk about, for example, Skelly meetings are not recorded generally. Now, sometimes the employee will insist on it. Technically, the person in the district who's conducting that meeting can say, no, this isn't recorded because it's a confidential matter, or they can make the decision to go ahead, yeah, go ahead and record it, but we're going to record it too. So everybody, the two sides have a similar copy. But generally, no. Statutory disciplinary hearings are court. We as lawyers generally court reporting because we love to have records of everything.
Right.
If you're going to make an important decision of firing someone or that kind of situation, you probably should have a recording. But whether it's required is another issue.
Normally, both sides have to agree to a recording, or it's illegal. You can't just tape record a conversation normally, but. Often, if it's a serious matter, parties want to preserve the record. Then, and as Larry says, as attorneys, if we're taking it to that next level, and with the understanding that it may be appealed to the a court of law or some other tribunal, then yeah, we would want to probably preserve the record and have some kind of evidence of what was actually said during the course of the proceedings.
What about during the investigative phase? Because typically an investigator works solo, and they come in, or sometimes they bring a note taker, but not always. It depends on a resource issue. So they will bring a recording device with them and then provide the union with a copy of that recording. I'm
hoping that they get permission from parties that are being interviewed, as well as if they're being represented to do the recording. I've done many investigations where I just had to write down from my notes and then subsequently put something together. But yeah, it's not required to have it recorded for it to be valid. Ultimately, you're going to be questioned often as the investigator as to the veracity of what you heard and the quality of your investigation. Who did you speak to? Did you listen to their witnesses as well as the accused witnesses, et cetera, et cetera? Hopefully that helps a little bit.
Under California law, under the Penal Code, if there's what's termed a confidential communication taking place, it cannot be recorded without the consent of both parties to the conversation. Okay. So generally, when I've done investigations, I'm like Guy, I rely on my handwritten information and I take good notes. Some investigators I do know, they will come in and they will put a recorder on the, now they can use a smartphone and say, I'm recording this, do you have any objections? If the person objects, they cannot record it. So that's really how that situation works.
Okay, so just for the record, that's different advice than we've been given in the past. So I just want to be clear on that, because I know that there's some concern, and probably from audience members as well.
Once again, we'd have to look, I mean, there may be a collective bargaining issue, there may be something in a statute, there may be something in a regulation or board policy. But generally, if someone's coming in, if you walk into a room and you want to talk to someone and you don't want other people to, you just want to talk to that person. For example, I'll give you a concrete example once again. There was a situation where an employee had complained about something, and there was a meeting set up with her in the, it was a K-12 district, so it was an associate superintendent, and she brought a representative, so he had me come in to help him. I was the district's general counsel. And we had this meeting, and we talked about her concerns and questions and whatever. And there was no recording or anything, and we didn't agree to record. And then a month or two later, she files a lawsuit, and she brings a tape of that meeting and plops it on the table saying this, that, and the other thing about this meeting. Well, unfortunately or fortunately, we were not aware of the recording. She had doctored the recording to make it sound like we had said something that we didn't say. So what we did, I had the associate superintendent file a criminal complaint against her because that violated the penal code. She surreptitiously recorded a confidential communication.
Just real quickly for Larry, it's Penal Code Section 632, and it says specifically, California makes it a crime to record or eavesdrop on any confidential communication, including a private conversation or telephone call, without the consent of all parties to the conversation.
And then in the course, she sued the district, tried to use that tape as evidence, and we got a court ruling that was excluded because it violated the penal code. So, recording things, you have to be very careful with that situation. You have to understand what situation you're in, if there's a contract or a policy that covers that. But I always tell folks, if someone's going to record something, everybody has to be aware. I don't care what your policy or contract says. By law, it's a criminal statute. Everybody has to be aware, and they have to agree.
Now, I have made the argument where someone had a device and it was there and it was plainly visible, and it was plainly visible that was being recorded, that they agreed through their actions. So that could be a possible way, but normally we would never advise that. We would always advise that you absolutely have to have their permission, preferably in writing or actually in the recording itself, where they say, I agree to be.
Generally what happens, like I said, is someone plops it down and starts recording something, and if you want to go forward and not create a real issue, you take your own smartphone on and plop it, so you make your own recording. So, well, there's an exception. There's an exception. There's always an exception for peace officers. So, okay, I'll just say that.
Several layers.
But anyway, that's how it starts. Basically, if something's going to be recorded, everybody should be aware of it. And actually, That's what the Police Officer's Bill of Rights says. Everybody needs to be aware that it's being recorded.
I just had a point of information in Board Policy 5500, Standards of Student Conduct, when they're talking about the student conduct hearings. Number 3 says there shall be a single verbatim recording of all student conduct. I think they meant hearings, except deliberations shall not be recorded. Well, the deliberation is just the SCO, student conduct officer, talking to himself, I guess. And it says the record shall be the property of the college. The student may receive a copy of the recording upon request. So the student hearings are recorded according to policy.
Thank you.
You keep on, you're going to be a paralegal now. You know that, right? All right, so we've gone through Patty Hearst. You guys get an A for that.
What was the answer to his question?
Oh, the answer, what processes do? Informal hearing. What is the district, or is the district required to comply with Ms. Hearst's demands? Well, the district she can have her attorney there, but with respect to her saying that there has to be a court reporter and the district has to pay for it. I mean, she didn't actually say that. She just wanted a court reporter. If she wants to pay for it, sure. But the district would not have to allocate resources because she demanded so. And what is the evidentiary standard? Preponderance of the evidence. She doesn't have the authority to change the standard of evidence, and that why? Because it has to be consistent and fair in accordance to policy and offered to everyone. So she doesn't get to make those changes because those are changes that affect more than just her. So now we're on page 32. Liberty exception for volunteers. Now this is important because as we had seen on slide 11, there's certain elements of our community that are not included in the statutory framework, which deals with employment. Volunteers are one, and it's important that we know what everyone's due process is as part of the community, or what everyone's, there's a liberty exception, and so there would be, what process would we follow in this instance? So the due process clause forbids arbitrary deprivations of liberty where a person's good name, reputation, honor, or integrity are at stake because of what the government is doing to that person. So the minimum requirements of the clause, meaning the due process clause, must be satisfied. And remember, when we talk about the minimum requirements, that's because you make a balancing test with respect to the interests, those being education first and the allocation of resources. But as we said before, the board and can take under consideration what their balancing test is going to be with respect to the policies that they implement. For instance, with respect to the student conduct hearings, as long as you meet the requirements of the law and you're responsible with respect to where you're allocating your resources. So you don't want to lawyer up, but if you want to make sure that if you feel like there's a broader or more open approach, then you can consider that as well. So there's notice, opportunity to be heard, and no formal hearing required. So we're going to go back to liberty interest because we have the Luby case that's helping us determine what the liberty interest is. So we're going to go back to slide 15, where we first talk about, oh, I'm sorry, it'll be slide 13, where we talk about what the liberty interest due process is. And then we talk about the liberty interest exception on slide 14. It's talking in the term of public employees, but it's the same interest that would be applicable with respect to volunteers. And it addresses stigma, not employment. So really, if you're dealing with a volunteer, you're not dealing with employment anyway. You're really dealing with that person's good name. So we're going to go back to our earlier slide, which is slide 32. So notice, opportunity to be heard, and no formal hearing required are the what process would be due with respect to the liberty exception for volunteers. Liberty exception for trustees is the same, because trustees are elected and trustees have an obligation with respect to the district. They don't have the property interest right we saw with respect to employees. So we're dealing with the same interest: notice, opportunity to be heard, and no formal hearing required. Where persons,
Could you explain what notice involves?
so notice, how much notice? Okay, let's go back to, I believe that we have what level of detail? So what, okay, liberty interest, what process is due? Name clearing hearing, notice of a meeting before a governmental body for the opportunity to be heard. So what you're going to need to know is what if you're going to have a name clearing hearing by Luby, you know that you've been defamed. You're saying that's not right, and I want my name cleared because you've asked for the opportunity to address the stigma.
Do you have the right to know what you're accused of?
So in a liberty interest with Luby, if we go back to Luby, that is a case where we had temporary employees. So we're dealing with the context of employment with the Luby case, where we had the officers that were temporary employees, and they were called up to the chief's office, and they were told they were being let go, and they weren't told what it was about, and there was some stigma involved, and they were summarily let go. And they brought this case because they wanted to have an opportunity to be free from stigma, although they knew that they could not get their jobs back because that right, they were temporary employees, they had a right not to be defamed. In that instance, you have a liberty interest. With respect to the trustee, we're talking about the stigma, not the property interest right. So it's not a person being let go. So or if it's a situation where we were with a temporary employee that was Pablo Picasso, he wasn't being accused of anything. He was dealing with the fact that Mr. Mondre had said that he was the actual author of Cubism. So in each liberty interest case, it may not be an accusation. It's because you know something, there's something being said about you, and you say, wait a minute, I have a right to hear my name.
If I might interject a little bit, sometimes we have issues where a board may want to censure another board member or other types of potential trustee misconduct. There may be bylaws that already address that the board has already developed to deal with that kind of issue, because that to me gets into liberty interest of that particular elected official that may want to clarify what may be perceived by others to have.
Well, my question actually does not deal with the liberty interest. I think it's a due process question, that if someone files a complaint against you, whistleblower complaint, do you have the right as a trustee to know what you're accused of?
So,
I see what you're saying.
whistleblower.
What kind of notice? I mean,
Let's go to whistleblower.
well, I didn't mean to
That's
make you jump.
Specific kind of statutory process.
Whistleblower. I think there's two things to know about whistleblower. One, and we're on slide 39. There's two types of whistleblower.
Thank you.
There are two types of whistleblower complaints. One is someone saying something untoward is happening with respect to in public government. Then there's the retaliation complaint. That's a written complaint that alleges that you've retaliated. So if there's a whistleblower complaint, that the government can say, well, we're just going to see if there's any validity to it. It doesn't mean that anybody's being accused of. There's no charges being brought against anybody. That means someone says, well, something's going on in accounting, someone's double dipping with respect to their receipts or whatever. They look and see whether there's any validity to it. Then, if they find that there's validity to it and they actually are going to say you violated a policy, that's when it gets into the complaint procedure, where it gets into the situation where you need to be notified because somebody's coming to you. They're saying, you've done this or that, and you're not going to be able to clear your name unless you know what they're actually talking about. Does that make sense?
I'll talk to you later. It's a little more complicated.
Dyer or Larry, you could chime in, but with respect to a whistleblower complaint, the whole idea of having the whistleblower is to make sure that there could be the investigation of misconduct without a person having to come forward and say, well, you could do it anonymously, just so
Right.
But if you're talking about being accused of something, that's actually allegations that have to do with how they could bring discipline or some sort of impact. So that one, do you have a right to know? And I would say you do have a right to know what you're being accused of.
Okay.
There's no way you're going to have an opportunity to be heard if you don't know what the subject matter is.
And that is the question that I was asking, so thank you.
Is there a specific complaint procedure in this district that has a process in it? Because generally, there's a policy that talks about how the complaints are handled. At some point, as we talked about in due process, first of all, the person, it's a basic fundamental fairness issue. You have a right to know what someone is doing. So the answer is yes at some point. Now, when we're doing investigations, we are very circumspect about that until the investigation is complete. And a lot of times when we meet with, for example, an employee, we only give them the general parameters of it, because a lot of times the concern is about retaliation.
Right.
If you would name witnesses and name people, and somehow the employee's going to go out and do something, which is why there's, if you want to go back to the whistleblower statute, there's a very strong part of the whistleblower statute that relates to retaliation.
Right.
That's page 38, sorry.
That doesn't mean the person accused doesn't have the right to know what's going on. They just need to be told, hey, we're giving you this information, but oh, by the way, don't do anything like retaliation, because that's a separate charge against someone.
All right, so we're going to go back to liberty interest for trustees. So we were talking about the right to the name clearing, and then we also talked about what happens if you're accused of misconduct and what type of liberty interest would be there too. Does anybody have any further questions about the liberty interest? So now we're on slide 34, and to recap, what processes do? So here's the test, permanent employees, what processes do? Okay, everybody's blood sugar's low, we have to hurry up and get to lunch. So for the permanent employees, you have the Skelly rights, the right to know if what the accusations are against you. You have your Weingarten rights, your Lieberger rights. You have somebody in there with you if they're making if there's formal charges being brought against you. You have a right to a hearing, right to refute the charges. Temporary employees, you have a liberty interest. Students, we have a student conduct policy, and there's an informal hearing process. Volunteers and trustees, we have the liberty interest. And so the analysis is the same issue, rule, and application. What is the interest or standing at issue? What is the statutory framework applicable to the issue? And what is the process outlined by case law, statute, or contract? So we're going to go really quickly through Title IX. And also, if you notice, and that's slide 35 at the bottom, this slide is verbatim from the United States Department of Ed Office of Civil Rights as of September 2017. So this was put out by Betsy DeVos, the department under Betsy DeVos, and it's a Q&A on campus sexual misconduct. And so it's just really an overview of what is required with respect to the Title IX process. And what we had mentioned before is that there's certain rules like federal law that have their own process. Title IX is one of them, where you have a process that's mandated by the Department of Education. And this is a sort of condensed version of what the Office of Civil Rights for the Department of Ed has put out with respect to what the due process procedures are following the rescission of the 2011 Dear Colleague letter. So we have a notice of the school's grievance procedures, There has to be the reasonably prompt timeline for the investigation, notify the parties of the outcome of the complaint. There has to be an impartial investigation, opportunity to be heard and to present witnesses. And then the school has to assure that it'll take steps to prevent reoccurrence of the sexual misconduct and to remedy its discriminatory effects as appropriate. We also have the overlay of state law. We have the affirmative consent law that is under Education Code Section 67386. That's on page 36. If you'll notice, with respect to sexual harassment, that the standard is preponderance of the evidence. That's in our state law, so that's the one that we would be applying. And there was just a recent, October 15th, there had been a new law that one of the state legislators assemblymen had submitted that was trying to bring forth a whole new set of rules for sexual misconduct. And Jerry Brown said, nope, we've got enough. We've got the affirmative consent law. It's called his veto letter, where he explains that he believes that we need to figure out what's going to happen with the federal law with respect to sexual harassment. So we don't need to enact any new laws in the interim, and that we already have the standards here at the time under the affirmative consent law. So we're not going to be adding more layers of law because we're still going through changes at the federal level, which mandates this particular issue for educational institutions. Does anybody have any questions? And we also have a particular complaint process with community colleges with respect to the state chancellor's office, where someone can file a complaint, and we have to make sure that we assess the complaint and investigate and attempt to resolve the matter. And also we have to notify the state chancellor's office of the outcome. I didn't put that slide in there because I was trying not to go too deeply into all the regulations. Gave you guys a break there. So whistleblower, we're on slide 38 now. And California whistleblowers are protected by specific statutes that prohibit retaliation. And that's really so the government could check itself. If somebody sees something going on, they could make a note of it. They could say something to somebody, and it could be reviewed and to find out if it's valid or not. With regard to a complaint by an employee against another employee, the investigative process that's utilized as a first step, or the investigative process is utilized as a first step to determine if sufficient facts exist to initiate disciplinary action. So you first have to figure out if it's valid. Just because someone says something doesn't mean it's true. You have to look into it first. And employers have a duty under state and federal law to conduct a prompt and appropriate investigation of charges or claims. And so we had already talked about a whistleblower complaint versus a retaliation claim. The whistleblower complaint is a protected disclosure, which is defined as a good faith communication based on or when carrying out a job duties. So really you're allowed to make these statements if you think it's in the best, if you think someone's not following regulation or doing something like embezzling or wasting taxpayer money or something to that effect. A retaliation complaint is a written complaint that alleges that a public employee retaliated by taking an adverse personnel action against the complainant because you made a protected disclosure, because you said that you thought that something was going wrong, or that you refused to obey an illegal order. So those are important so that we can check ourselves, because we don't want even more layers of regulation. I think there's a lot of paperwork as it is with respect to state and federal government. Even more regulation would be required if we didn't have this system where people could say if they see something going on. And whistleblower protections. The employer has a burden of proof to demonstrate by clear and convincing evidence that the alleged action would have occurred for legitimate independent reasons, even if the employee had not engaged in activities protected by the whistleblower statute. So in other words, if someone gets transferred, or they get a demotion, or they get a negative personnel action after they've made a whistleblower complaint, the institution has to show that it wasn't related. Now, I think this is really important because sometimes whistleblower protections are brought because you have to spend a whole lot of time determining whether or not they're valid at all before you can get back to the issue of whether, and you have to have clear and convincing evidence if you're going to take a personnel action. So what it does with respect to the government is, if you're a administrator or supervisor and you're trying to give someone an evaluation, or if you're going to demote them anyway, they could file whistleblower action, and they're going to send you around the long way home to try and to be able to get the evidence to show by clear and convincing evidence that the alleged action would have occurred otherwise. So there's an upside and a downside, like just about everything else in, trying to have a cooperative society. People can misuse whistleblower, or they can use it to make your institutions run more efficiently. So whistleblower claims, what processes do? So Larry or Guy, you guys want to take this one?
Well, basically, your collective bargaining agreements under the EERA will provide a certain level of due process. It's a mandatory subject of bargaining, and so I'm certain that you have collective bargaining agreements. And I think I heard Greg that you have a progressive discipline, very robust progressive discipline process that deals with letters of oral warnings as well as written warnings. So that's the process.
But could you speak to those who are not full-time employees?
So the collective bargaining agreements deal with people who are represented.
Well, but like, for instance, there's a due process clause in our faculty association.
Right, so they're represented.
But they also represent the adjunct faculty.
Mm-hmm.
But the district would not allow them to cover adjuncts under the due process clause. So what
I'd have to see the contract language and understand why that wasn't happening. I can't speak to that specific because I haven't read your contract.
Well, but what I'm concerned is that the whistleblower, shouldn't it cover everyone? Shouldn't it cover every type of employee, volunteer, part-time, full-time?
So whistleblower is separate and apart from your collective bargaining agreement.
Well, the protection, shouldn't they cover everyone or own?
They do.
Yeah,
Whistleblower is a state statute that covers absolutely everybody.
Right.
And then the education code as a statute.
Okay, so
But if somebody is accused of wrongdoing, that's the part. So if somebody, whistleblower protects everybody, but if someone makes a whistleblower claim, and then you do an evaluation, you do an investigation, you have to find out whether the person was telling the truth in the first place. So if you find out that there was actually a violation of policy, that's when it gets to discipline, and that's when it gets to what do you do with respect to the due process if you're accused of misconduct.
And if you're subject to the collective bargaining agreement. So you've made a determination that something may have gone inappropriate. So you've done your whistleblower portion. Now you're looking at the standing of that particular employee. If that employee is part of a represented group and they have a contract, then you would normally follow that contract to actually impose the discipline or the actual hearing in order to substantiate the investigation.
but let's say that an adjunct, after the investigation, they had found something to do wrong, and they're specifically left out of the due process clause in the contract that covers them, so they have no due process?
Well, the adjuncts have that liberty interest. If they're accused of misconduct, they have a right to clear their name. You still have the LUBI interest, the liberty interest exception process. So the adjuncts as temporary employees can be dismissed without cause.
Right.
But what we saw before when we were on our earlier slides with the liberty interest exception, that's for volunteers, is that you don't have a right to the job, but you do have a right not to be defamed.
It would be a lower standard. If it's a liberty interest hearing, it would just be notice, opportunity to be heard.
So if we go back to slide 15, there's still, if there's been a publication or of arguably adverse and stigmatizing information about the employee, that employee is entitled to a name-clearing hearing, which provides the opportunity for the employee to clear their name on the record, but not the right to get their job back. And that's what the officers in LUBI experienced. They were temporary. They couldn't get their job back, but they should not have to carry a stigma of being accused of misconduct because they have a right to go, they should be free to go get a job somewhere else without carrying the stigma. So if the collective bargaining is disciplinary process doesn't include the adjuncts, it may be because they're temporary and they could be dismissed.
And they could have their classes cut, and while they might perceive that's retaliation, it wouldn't be retaliation.
Well, so we're on slide 12. If a person claims retaliation, then you have to go through the process to see whether or not
It's true.
there actually is.
Right, and there's probably a provision about when classes, notification of when a class is not going to be offered and that kind of thing. So it kind of gets into maybe other non-disciplinary reasons why that position was, or why they aren't going to have classes for this particular semester or not.
At my school, one of our adjunct faculty she's a friend of mine, and she's very outspoken. She was the faculty rep, the adjunct faculty rep, until just recently. There was another election, but her classes are classes that meet certain it's not your major, but it's your it's a requirement, but it's not her, unless you're a major in her particular area. So she fills a lot of electives, but sometimes we don't know until right before classes start, or like right now we're trying to figure out what classes are going to be in the intersession. And so sometimes it comes up to the end to find out. But, the question is always, is it for something, has she been speaking out? We just negotiated office hours for adjunct faculty, and then we were trying to figure out where we're going to get the money from for the adjunct faculty. And so it's always a question where, we're waiting to see what's going to happen with her classes. Is she going to get her classes? Is it going to be because she's speaking out? And then she's also, you don't have a full vote in the union when you're adjunct. And so not everybody is her friend, even if they're faculty members too. And so, she and I sit over many cups of coffee and trying to figure out what's happening and how to support and advocate for her, but also making sure that it's not a retaliatory thing, and it's not a situation where she's just not filling her classes, but that she's not being treated unfairly. The fact that she is outspoken. So that's something. If anytime you're an advocate for something, you're always going to wonder in the back of your head. Frankly, you can't not stand up for yourself, because it doesn't work. If you don't stand up for yourself, you get stepped on. But if you stand up for yourself, you wonder if you're being targeted. So, with respect to the rights of the adjunct faculty, if there's no due process in the collective bargaining agreement, it's likely because they don't have the property interest in the job, but they still have a right not to be defamed, and they still have a right to be treated fairly. Anybody have any questions?
And that adjunct faculty member may have some remedy under the whistleblower statute, but that's a whole separate deal. And I'm trying to remember if whistleblower includes reinstatement, even of a temporary employee. We'd have to look at that. So it's like thinking about two different tracks. There's employment and there's whistleblower. Sometimes they intersect, and you have to be very careful in delineating between the two and making sure that the protections of one don't slop into another one, but they both have protective provisions to them. So,
all right.
It's very whistleblower. When I started out in this business a long time ago, before the earth cooled, there wasn't a lot of this whistleblower. Since then, the statutes have been passed, and it's a difficult process. It's something that has to be carefully considered and carefully investigated.
All right, so we are back. Does anybody have any more questions? We're going to go through our last hypothetical on page 42. And this is a whistleblower hypothetical. So does everybody see slide 42? We have Sally Silkwood, who reports to her supervisor, who's an associate dean in the chem department, and she and her colleague, Erin Brockovich, have observed illegal government activity in the science lab at the community college district. So the first question is, Sally's complaint confidential under the whistleblower statute? Remember, Sally's not accused. What Sally's doing, if she's going to make a whistleblower complaint, is that confidential? Yep, you don't have to make yourself known if you're just saying, I think this is wrong. Why? Because first it has to be investigated, and if it's investigated, that investigation could determine whether or not someone did something actually wrong. And if they did something actually wrong, then there would be a disciplinary activity or a disciplinary process that would have to be followed that is covered with respect to the statutory framework, whether the employee's temporary or private, or what their standing is. So you can say if you see something wrong. And it's up to the institution to do the investigation, find out if it's legitimate, and if they come up with wrongdoing in the process, then that triggers another process, disciplinary process. So Sally's report is investigated by the district and found to be accurate. It's discovered that the dean of the College of Arts and Sciences is conducting experiments with hazardous materials without proper regulatory registrations and safety protocols. Okay, does anyone remember flubber? And Sally's work hours are, that should be an R, not an and, are drastically reduced, and she files a retaliation complaint. So here's the part where you get into a retaliation complaint. So that's a violation of the whistleblower statute, and it's also, you can't retaliate against people according to the conduct, the district conduct. So is the retaliation complaint confidential, and what processes do? Anybody have any idea? So remember, the burden is on if someone files a retaliation complaint, the institution has to show through clear and convincing evidence. So Sally can throw that rock. She can say, wait a minute, and maybe, oftentimes there's not a whole lot of staff, so people are going to know who's conducting experiments. So she can say, look, they reduced my hours because I told on these guys, and they can do something really dangerous in the chem lab. So you could put two and two together and kind of figure out that, or you'd have to do the investigation. But the fact that she is filing a retaliation complaint, she could do that. But you have to investigate to find out whether or not there's proof for that. So is the retaliation complaint confidential? Guy and Larry, you guys want to answer this one?
Is it confidential?
The retaliation, not the whistleblower, the retaliation complaint.
I would say yes.
Larry, what do you think? I say no. What do you say, Larry? You see, we can even stump the lawyers.
Confidential in the sense of what? I mean, if her hours are reduced, and she had filed this complaint, the complaint was determined to be founded, to be accurate. Then at that point, what is happening is the burden shifts to the employer to provide an independent reason for the reduction of her hours, separate and apart from the whistleblower complaint. So why would it be relevant that it's confidential or not?
Just to make your brain work.
I mean, she would have to put together a written complaint and allege.
I think it's, because people probably...
Well, what happens is that her hours are reduced, and then she files a complaint saying, look, I filed this thing. You're aware of it, employer, because it's in your records. And that's the reason and this dean who supervises me recommended this to me. Now, no, I won't say this. She probably would try and find other circumstances too. Maybe she's the only one with her work hours being reduced.
People talk, and often that person, unfortunately, may make a comment to that particular employee. Thanks for going after me, and now I'm doing X, Y, or Z. So
really, the thing is, with the retaliation, with the whistleblower complaint, it is confidential. With any complaint, you don't want to go publicizing it, because that makes matters worse. But with a retaliation complaint, how are you going to investigate it? You've got to go talk to the claimant, the accuser, and the accused. You've got to talk to everybody. With a whistleblower complaint, you can go in and you could just start auditing the Chem department, see what materials they ordered, where they're stored, and whether they're filling out their hazmat regs. You don't have to say, I'm coming in here because somebody made a complaint. You could just do the investigation. But if you're going to do a retaliation complaint and there's possible discipline, that's why I'm asking, is it confidential? Because somebody's been accused of something. And how are you going to do the investigation unless you go to the accused and the accuser? Yeah, you don't want, so we do know that you have to be careful. You can't start saying stuff about people. You got to be really careful. And then you don't want to defame someone, but you want to explain what's happened. And then you don't want to say you've not been filing your hazmats when the guy's actually ordering uranium, which has really huge. So you don't want to say, close the back door in case you start investigating, you find out a whole lot worse. But you're right, you don't want to defame them, but you want to make it as confidential as you can, but still notify the accused of what happened. Does anybody have any questions? It's a very difficult balancing test. It always is.
It's a very, very challenging area, whistleblower law.
So what processes do? Guy and Larry? Due process for 200.
Well, as we've noted earlier, the statute tells us what processes do. If we go forward with some sort of, if we go forward with reducing our work hours, as you file a complaint probably under the district's complaint process, she could eventually probably file an action to have her work hours reinstated, and the district would then still have to prove by clear and convincing evidence, which, as Guy pointed out earlier, is a higher standard of evidence than just preponderance. It's more than a feather. It's a ham sandwich, or whatever what you want to say. Something, we're getting close to.
And speaking about ham sandwiches, can we have a break now for lunch?
We pretty much are.
I think we are, yeah.
We're finished.
This is actually, the last one was going to be reviewing we were going to talk about the policies and procedures and have a discussion, review, and reflection, but we have already been assisted in that to some degree.
Well, and we can continue after lunch.
Okay. Well, so there was a question answer, and then there's a thank you. So.
And thank Larry for mentioning ham sandwiches.
But as I understand it, that everyone in the room is invited. Leslie, I'll have to send you a picture. So.
Thank you.
We're going to have questions after lunch.
Oh, you will? Yeah, if you want.
Well, always ask us questions.
So we'll just take a recess now.